The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have three cases that will be submitted. They are David Taft Jr. versus Iowa District Court for Lynn County. Second case is in the interest of MRW and ZJW. And the final case is the Iowa Supreme Court Attorney Disciplinary Board versus Jamie Darama. That last case is submitted without an argument, and we'll now hear the arguments in the Taft case. Mr. Mears.
One of the few times I get to say good afternoon. Most of the time I'm over here in the morning. So David Taft is back. I am perhaps the only private court-appointed lawyer in the state with one of these cases, and that having worked really, really hard in a couple of cases over about 7 or 8 years, this past September, I was rewarded by getting to have the actual jury trial for David Taft. David Taft, after all his cycles, managed to go 6 months without having a report, and actually, at least temporarily, had a relapse prevention plan that was approved. So that for a short time, he qualified actually for having a final hearing with regard to transitional release. So as I say, we're back here again today dealing with Chapter 229 on this fairly narrow appeal, where the question has to do with the particulars of Section 229A.8a.
Mr. Mears, before I get into that, what has happened to your client? What's his current situation?
We lost the jury trial, and that is going to be proceeding with the appeal process, and I'll be writing a brief on that in the next month.
Does that moot out this proceeding, though? I mean, you got your hearing, you had your jury trial, and everything you're claiming was an impediment to getting those things.
Well, we addressed briefly the question of mootness sort of during the briefing, and that we withdrew the claim a year ago, 10 months ago, with regard to the merits of whether he should get a final hearing, but that we requested to continue and were given permission to submit amended briefs with regard to the 8A issues, because it was anticipated that those would be probably recurring issues.
Okay, so you want us to decide this case on the principle that it's a recurring issue not likely to be reached, rather than a real controversy between your clients, since he's got past that.
Well, yes, even though to some extent in many cases under 229, by the time you decide the case, that the cycles have moved on. And so that, for example, if we were to give somebody a new, or said they should have a hearing, they're probably going to be having consideration, at least for the hearing, already for the new cycle. So that's kind of a feature of the beast.
Is he currently ineligible for transition living because he's under a major report in the last 6 months?
Yes. And that I might add that what happened at the jury trial was that about 6 weeks prior to the jury trial, he picked up a major report raising the question of whether or not that would sort of, which 6 months would you even be looking at? And that once he had gone 6 months without a report, was that good enough? And that at least for purposes of proceeding to a jury trial on the issue, the Attorney General's office did not raise that point. On the other hand, I was stuck with a jury instruction that mirrored 8A, where the jury was told that if he hadn't gone 6 months without a report, that, or whatever the exact language is, no major disciplinary report had been issued for a period of 6 months, and in fact, the jury found he was not suitable either for transitional release or discharge.
But wait a minute, if the jury for transitional release, he has to show that he's no longer, one of the things he has to show is that he's no longer a high risk to reoffend, right?
Yes.
And the jury found that he was likely to reoffend.
Well, the jury returned a verdict saying that he was not going to be discharged. I mean, I'm not sure how detailed.
They have to find at the final hearing that he was such that he had a mental abnormality such that he was likely to engage in predatory acts that constitute sexually violent offenses if discharged. Isn't that a finding they had to make?
Yes, that's the bottom line of the one. I mean, there are two jury instructions that you can get. I mean, one has to do with suitability for discharge, and the other is suitability for transitional release. And the jury found against him on both of those at the jury trial in September. But that this issue of David, I've had him now for 8 years, and David periodically gets these, what I at least characterize as non-sexually related, non-serious incident reports, disciplinary reports, which has in the past disqualified him. And I think it's absolutely clear it's a recurring issue. And for that reason, I think that when we were thinking about what to say to the court about whether the issue was moot, that the Attorney General's office position was that they also agreed that this was not moot. But that's the way the statute works. And what's ironic about it, from the perspective of having tried one of these, is that transitional release can be thought of as sort of the gradual release prior to discharge. But that the irony is that because the legislature put this criteria together, that it is harder to establish the criteria for the gradual release program than it is for the discharge. Certainly, you're going to have cases where you're going to.
But we don't have real discharge. I mean, we have stages 1 through 4 or 5, whatever it is, transitional release. Then we have release with supervision, release without supervision, or discharge.
Right.
I mean, you're skipping over the middle one there.
You mean the
release with supervision or release without supervision, which seems to be where many of these people are now.
Well, and certainly that received sort of a good deal more of an impetus after the Matlock case. And I might add, but the point about the transitional release program is this is the one that's run by the Counsel unit. That is, maybe you can get a release with discharge where you're going to get to go be supervised by your probation officer in Lynn County and stay at the halfway house. But that if what you want to do is have the Counsel unit's transitional release program supervise you starting to go back into the community on a gradual program, you're disqualified. And that I would, as a person who has worked with institutionalized persons all my life as clients, that there are real pluses to the kind of transitional release program that Counsel runs that you may not get with release with supervision.
And I think you make some excellent points. The concern is, but one of the most salient points it seems to me you make is that it sounds almost like the what you have to show for transitional release or is a heavier burden than to be released.
Sure.
And that being the case, is there really any reason for us to address these conditions? The one having to do with no D&E, no major discipline reports, and a detailed relapse prevention plan. I mean, what is the point of addressing those.
Well, but the fact that it's harder to get a court order that puts you into transitional release than puts you into discharge doesn't mean there's something to be said for the transitional release program. That David Taft may very well do better in the transitional release program, where he's getting to go out into the community, at least as an initial matter, 1 day a week. That he doesn't get that under release with supervision, and that, you have a gradation of control, or you have gradual release, and in a ideal world, you might have transitional release before you had release to discharge. Discharge with supervision. But you can't, because of these provisions, and I might add, these are not provisions that in some kind of a fashion were imposed by DHS in trying to decide what's rational. These are provisions that for some reason were put in by the legislature.
You read the code requiring transitional release before you get release with supervision?
Absolutely not.
So you can actually be from stage 3 or stage 2 or 1, any of the stages, if you can prove, the release with or without supervision provisions, you could actually get out without having to do the transitional program first.
That's correct. But that doesn't mean that the transitional release program isn't a really good idea, or isn't something that perhaps ought to be more available to people before they go to discharge with supervision.
Yes, but that, and you may well be right, but that strikes me as kind of a policy argument. In terms of your due process argument, as I understood it, is that D&E, this relapse prevention plan and the discipline reports, those are kind of arbitrary requirements. But if the person is likely to reoffend anyway and could be completely held at CUSO without even being put in transitional release, how is it a due process violation to impose those requirements on transitional release? That's
Well,
the constitutional question.
This court in Matlock, I believe, said that due process, as a substantive and probably as a procedural matter, extended all the way through to the bitter end. And that it has to be the case that the constitutional protection for due process applies to transitional release.
But Matlock was someone who no longer met the SVP criteria. He no longer was likely to, the court had made a finding that he was no longer likely to commit further sexually violent offenses.
So are you suggesting you would get due process and then it would stop for a while and then pick up?
The state analogizes this to a situation of somebody who's lawfully incarcerated, and we, as courts, normally don't get, once the person is lawfully incarcerated, we don't normally get involved in the levels of supervision within the prisons. And so their argument is this is analogous to that, and it seems maybe there's something to support that analogy.
But the legislature in 1995, when they enacted 229, provided an elaborate procedure for being able to go to transitional release.
If you read Swanson, I mean, transitional release in phase 1, 2, 3, and 4 are treatment type programs. Purely under the purview of the unit about who's in what area at what stage of treatment. And I don't know if we can intercede or intervene in those things and say, well, this is not right for treatment because you should be able to go to you should be able to transitional because you don't have a major thing, and things like that. Those are decisions made by the legislature on how someone should be treated and enforced by the medical personnel at the institution.
But this isn't a case of prison and deciding whether due process protects whether you get to go to work release. This is a statute where the legislature has provided for an elaborate hearing process, including a jury trial, on whether you get to go to the work release program, the transitional release. And that once the legislature has done that, if they had said, this is just a different level system, we're gonna take it all out. But they have a process. You get to have a hearing. You get to have counsel and a jury trial potentially on whether you're gonna go to transitional release. And that when that happens, you can't set arbitrary barriers up. Barriers that in fact don't relate to whether or not somebody is likely to reoffend or have nothing to do with or are not related to sexual reoffending.
Let's go, I think you're getting, at least for me, at the heart of part of this case, and that is this requirement so arbitrary as to offend due process? And I wonder, and I think you would agree, I think, that a history of infractions might well be considered consistent with due process as to whether one might get into a transitional release program. Now, I know that, I mean, it's a per se rule, as I understand it, but if the rule were a history of discipline could be considered in whether or not one is qualified for transitional release, would you object to that?
No, I think that's already found in
Okay.
the other provisions.
So your objection is it's an irrebuttable presumption, I take it, that you're not qualified
That's right.
if you have a major report.
That's right.
And so your view of it would be, I take it, that even if you had a very low percentage of risk, I mean, not a preponderance, not more likely than not, you might be at, let's just, my hypothetical 5%, 2%. But you had a major infraction for a nail clipper, you would be automatically disqualified for transitional release under the current rule.
Correct.
All right. And that strikes me as potentially problematic. But that's not your case quite either, is it? You don't have a record that shows that your client is 5% recidivist or whatever. I don't believe, right?
That's correct.
All right, so make the case for me. I mean, I think this per se rule in some contexts might be arbitrary. The 5% case that I'm suggesting, you might think, my golly, 5% likelihood of recidivating, all the experts agree, and he had a nail clipper and he's not going to transitional release. That might strike us as being an odd judgment. But does that, the mere fact that there might be irrational application of the rule in one setting, does that allow you to topple the rule entirely?
Well, the problem for someone like David Taft, it seems to me, is that, you know, when he got a report, 3 weeks before the jury trial, he got like 3 of them. That is that having gotten one, the incentive was gone. That is that there is no reason for this provision. They've got the protection. They've got the ability to argue in several of the others that a repeat rule violator, even if you assume that any of the violations are serious, that is going to be disqualified. But that the legislature now says, you've got this elaborate process for having even a jury trial on whether you go to transitional release, one nail clipper report, or putting the beans in the microwave. That was my favorite from one of the last appeals. That, or giving a note to your therapist about how frustrated you are with a couple of people and being in so long, that disqualifies you from that entire process. And I believe that that's arbitrary. I might add, if I could have 30 seconds, there is the second issue, which did come up at the last minute in this particular cycle, having to do with a approved relapse plan. And that their relapse plans apparently are like 50 pages long, and they work on them and they put them on the computer and they talk about what's going to happen if they get in an elevator with a cute girl or something like that. That the literal reading of paragraph D, which is what the state got the judge to say this last time, was that this relapse plan has to actually be approved by CUSO before you in fact before you qualify for having this elaborate process about going there. That again, the opinion of our expert was that the plan that he had was perfectly fine, and that our position was that in that case, the issue should have gone to the trier of fact in a final hearing as opposed to, again, disqualification. Because as a matter of construction, if the legislature intended to give a hearing on this, where there could be a contest, at the moment they've got a veto. All they have to do to keep David Taft from never going to transitional release is just never approve his plan.
If we interpreted the approval to be subject to a reasonability requirement of some kind, would that satisfy any constitutional infirmity?
It certainly helps.
I'm-
No, I mean, I don't mean to be flip. I mean that there are other provisions here where it then becomes a jury question, essentially, where the experts talk about, I'm sorry.
Surely, I mean, it's a little bit like the misconduct report thing too. Surely having a relapse plan of some kind is a sensible criteria for determining eligibility for a transitional program, just as your disciplinary record is, in some sense, kind of, you'd be interested in knowing what disciplinary record is. And I sense that your objection is really not so much with the consideration of a relapse plan or consideration of a disciplinary jacket, but it's kind of automatic disqualifying features, kind of, quote, no matter what. And that therein lies the problem, I guess. But I think you'd concede, and don't let me, push you in a position you don't want to go, but I think you would concede that the notion of developing a relapse plan is rationally related to the underlying program. It's the automatic veto that troubles you.
Thank you. Mr. Cormally?
Mr. Chief Justice, may it please the court. This court in Swanson stated that the failure of a person to progress in treatment because of the issuance of a major behavior report is not an adverse action, but it's a part of the treatment under a cognitive behavioral model. And while the issues in this case are slightly different, the issue is the same.
Excuse me, counsel, would you put the microphone up? Thank you.
Sorry, Your Honor. David Taft's failure to progress to transitional release doesn't show any constitutional infirmity. It shows that David Taft still struggles with the antisocial personality disorder.
But 80% of prisoners have antisocial personality disorder. I am troubled by the automatic feature of the major report. I think it's clear that, as I've said before in other questioning, that the disciplinary nature of the person is relevant and germane. But to say that one report automatically disqualifies, it strikes me as having some arbitrary features to it. That may not be enough to pull down the rule, as I was suggesting. The mere fact that a rule can be arbitrarily applied in one setting may not mean it's invalid. But the mere existence of one major disciplinary report as an automatic disqualifier for a statutorily created transitional program, at least has got me listening. So
Justice Adelman, I appreciate that concern, and in many ways, David Taft offers the ideal example to talk about that concern. Because as Mr. Mears alluded to, Mr. Taft has had a long history of behavioral difficulties. I think we start from the premise that pretty much everybody at CUSO is going to have antisocial personality traits. It's right there in the legislative findings. 80% of inmates might have those features. it's probably higher than that at CUSO, and these particular folks probably have a higher degree of antisocial traits than your normal prison inmate. And David Taft, again, is a good example of that. You talk about arbitrariness. The process of issuing a behavior report isn't simply that somebody says, you did something wrong, we're writing you up. You know, there's a process that the handbook lays out, that this court talked about in Swanson, that Dr. Thomas talked about at the district court. Mr. Taft is told by a security staff that's an infraction. He might write it up as an incident report. That incident report is going to be investigated by a higher level superior, the TPS, and the TPS is going to make the decision as to whether or not that infraction rises the level of a major discipline report. Mr. Mears brought up the beans example, and I know he likes to talk about that one as one that is silly, and on its face it absolutely sounds ridiculous. He got a report because he put a bowl of beans in the microwave. You have to look at that in context of David Taft at that institution in the process of these investigations. There's one communal microwave. Mr. Taft has put a bowl of beans in the microwave. He's been
This consideration you're just going into, which I think is actually quite germane, I mean, I'm interested in it. But the rule in terms of eligibility for the transitional release doesn't allow this development. If you have a major infraction, that's it. And what troubles me some about it is, I mean, frankly, it's very blunt. I mean, rules are always very blunt. One can argue that we need blunt tools for efficiency purposes or whatever, but it seems to me the problem with the rule, if there is a problem, I mean, the problem he's certainly raising and I'm exploring, is look, it's a one-size-fits-all. It is not related to the likelihood of success in transitional living. It's not related to sexual offenses. It's not related to the reason he's there necessarily, or it might be, depending on the nature of the infraction and how often do we have it. If you had an inmate who had 30 I mean, just repetitively violated the rules and so forth and so on, you might say, God, he's not a good candidate for transitional living, and I get that. But this is a kind of a tripwire, or arguably so. One major infraction, you've got a whole book of rules. Some of them are fairly discretionary in terms of the call of the staff.
Well, Justice Abel, I think that the issuance of a behavior report requires the reliance on professional judgment as required in Youngberg. The criteria in the statute, do you have a report, is objective in the statute, but the issuance of the report is not. It is in the discretion of the staff as to whether or not any particular infraction rises to the level of a behavior report.
That's the problem that is bugging me, because that discretion, as evidenced by this case, allows a major infraction report for possession of a nail clipper. I mean, that just sounds so ridiculous.
Sure, and here I think, again, in the context of somebody with antisocial personality disorder, and Dr. Thomas in her report I think addresses this very succinctly. When you have someone who does not care about the rules and is only concerned about getting their needs met, that's the concern with the discipline. It's not the act that gave rise to the discipline, it's the mentality underlying it and the progress towards being able to conform behavior to social norms, which is the central problem with people with ASPD. When Mr. Taft picks up a behavior report because of something that seems tangential at best.
For example, let's say the rule required you to part your hair on the left rather than the right, and Mr. Taft says, no, I'm going to part it. I'm going to part it the way I want. In your view, staff discretion, agency rule, that's enough, right?
You know, the hair combing example, I think, is probably a little different because I think there's probably some other rights involved there.
But how is it different than the nail clipper?
Because Mr. Taft has been told repeatedly, having this is not allowed because of the danger it poses, because other inmates or other patients aren't allowed to have this type of item. And Mr. Taft has ignored those rules because, as Dr. Thomas put it, He doesn't care about the rules as long as he gets his needs met. And that is the behavior that underlied his sexual offending in the first place.
So the distinction about the clippers, you're arguing it's a matter of safety. Because in my hypothetical, if he repeatedly refuses to part his hair on the right side, that kind of persistent disobedience would be enough.
You know, I think the arbitrariness of that particular rule and the lack of relation to any sort of institutional, order, I think that rule would probably not. I guess I have a problem with that particular rule giving rise to a major report. I can't imagine a scenario in which that would actually be the case, because the rules at CUSO are not arbitrary. They're made up because this is a group of people that have to live together in this setting under these conditions, and there are lots of different treatment needs that need to be met. And being able to function in that environment is sort of a microcosm of how are people going to behave when they get out on the street. Because let's be honest.
You know, I sorry to interrupt you. I agree with about 80% of what you're saying, except it doesn't square with what I understand to be what I call, automatic tripwire. That may be a rhetorical device, but you're looking out the window at a fancy car, write them up. You're instructed not to look at the fancy car, to write them up. Now, does that really disqualify someone from transitional living? Now, if he's again, you're kind of arguing that, well, people who do these major reports have problems with authority, and if that were true, I would buy into it. I think there is a place for discretion in determining whether someone qualifies for, kind of transitional programming. But the scope of the major infractions is huge. There's a kaleidoscope of major infractions. And you have one within the last 6 months, and you bring up the cannon and blast them out of transitional release. It seems kind of not disproportionate, it's not very well tailored. If you would have said in violation of a major infraction that affects the ability of prison staff to kind of control the behavior, et cetera, something like that, but this is not a rifle. You got a blunderbuss going. And, at some point you have to do general characterizations, I guess, but isn't this kind of far afield?
Well, Justice Apple, to address the hypothetical you gave Mr. Mears about the person with the 5% recidivism rate that got dinged for a nail clipper. In that scenario, transitional release is meant to be the 5th phase of the CUSO program, right? It's not for everybody. It's, as Mr. Mears said, it's a good idea. But one of the things it requires, and even more so than probably even living on the committed side, is the ability to follow the institutional rules. If there's somebody who's got a 5% recidivism rate, well, in the first place, I think that person's probably
Not being
out the door. But if somebody's a close call, release with supervision is the appropriate avenue. And what can happen in that scenario is that then the court, in connection with the department, can develop a release plan that does fit that individual, that might include living in the transitional release unit at Cherokee or living somewhere in the community, but something more specifically tailored to that individual. Transitional release provides an avenue, and probably the best avenue, for the most people to progress through treatment. I think right now there are 15 people in transitional release, and there's another 10 that have moved from transitional release to release with supervision and on into the community. So it works for some people. It does not work in every case. It's again, what the legislature put forth is the best practice, but it may not work in every case.
How do you respond to Mr. Mears' argument, when I was questioning him earlier, where I get the notion that your argument that this is just kind of like, different security levels or different disciplinary levels within a prison that we don't normally get involved with. There's no due process, right? But the difference here is this wasn't done, these rules about no major discipline reports and so forth, that wasn't done by, like, the warden. The legislature actually put all of this together, and then when they did, they created a hearing. And doesn't the fact that the legislature has a hearing mechanism, in effect, create a due process right to the on the part of the respondent or the inmate.
Well, Justice Mansfield, I think there's the due process right that's involved is the patient has the right to go to court every year and petition for release. That's a two-level process, so there's due process afforded to the person at that point. With respect to the issuance of the report, if you're suggesting that there needs to be an administrative law judge proceeding adjudicating the behavior reports, you know, that was foreclosed by this court in Swanson. It was actually foreclosed more recently in a federal district court case brought by Mr. Taft in an opinion by Judge O'Brien, that the mechanisms for behavior reports are what they really are treatment documents, right? And so therefore they fall under the Youngberg standard of, is their professional judgment being exercised? So if this were a case where having a nail clipper or having a bowl of beans in the microwave automatically every time required a major behavior report, then I think there would be a due process problem. But that's not the situation. What happens instead is one person notes the incident, another person investigates and decides whether or not it's found. And so I think that satisfies the due process protections required by Youngberg, because at the end of the day, while there's some analogies to prison, there's some analogies to the mental health that was at issue in Youngberg, and so it's not a perfect fit in either situation. Really, transitional release, and I think I said this quite a bit in my brief, is there's no liberty interest in it, right? It's a phase of treatment. Mr. Mears in his brief says that Mr. Taft has an interest in not being locked up. I don't think anybody would disagree with that. But the rate at which Mr. Taft progresses through treatment is largely up to Mr. Taft and the professional judgment of his treatment providers. And the due process implications that come about are addressed at the trial court level when these issues come before trial. And if the person has a major behavior report that disqualifies him from transitional release, it does not foreclose the opportunity to be discharged or to be placed on release with supervision. And so I don't think the liberty interest that would give rise to due process concerns is present.
What about the relapse plan issue? You know, the claim is, well, you know, you can arbitrarily just say, well, we're not going to approve it. I made the suggestion that, well, maybe there's a reasonability requirement on approval, although I'm not saying necessarily that's required. But what's your view on that issue? Would a reasonability requirement, does that make sense? Does it not make sense? What's your view on that?
You know, Justice Apple, I think actually the reasonability requirement is already there in the form of the Youngberg requirement of professional judgment. You know, when the treatment, and I see my time has expired.
So in other words, if I said this is Tuesday, I don't approve relapse plans on Tuesday, that would be a due process violation, surely.
Because there would be no exercise of professional judgment there.
So as long as there's an exercise of professional judgment in connection with the lack of approval of the relapse plan, your view would be that comports with due process.
Yes, that's it.
Chief Counsel, what's the state's position on mootness in light of the jury findings?
Yeah, thank you. The mootness issue is difficult, and I think also the other one is ripeness. You know, in some cases, this case isn't ripe. Mr. Taft doesn't meet, 7 of the other criteria for transitional release. As a practical matter, it may be in Mr. Taft's case, and probably in the case of the majority of antisocial folks like this, that this case might never be ripe because, as Dr. Thomas put it in her deposition, people don't just get disqualified from transitional release based on this one concern. There's always other issues. There's always, one thing you see with people with multiple disciplinary reports is they have a continuing elevated risk of reoffense, and they show difficulty with insight and these other criteria. So I think the ripeness issue that the district court addressed is also present. But again, specifically to mootness, to me, this is the classic example of something being capable of repetition and evading review. Especially because, as Mr. Mears has put it before, it's a Groundhog Day type proceeding. It comes up again every year. When you have somebody like Mr. Taft who will go in and out of eligibility based on his propensity to pick up discipline reports, it might be moot today but not tomorrow. So.
Follow up on that. I mean, wouldn't it be a better case to test the constitutionality of D and E, the relapse prevention and the major discipline report, in a case where the person would otherwise qualify for transitional release?
Absolutely. I think that would absolutely be a better case. But the difficulty is, as I was trying to explain, and I think I got lost in my own thoughts, I don't know that that case is ever going to come, because the people that don't have a relapse prevention plan approved and can't abide by this 6-month rule are also the people that are going to have difficulty in treatment more generally, difficulty with insight and difficulty expressing compassion for their victims. So while I think, yes, this case is probably not ripe for review based on that issue, it may be a case that is never ripe based on the type of people that we're dealing with. Thank you.
Thank you as well, Counsel. Mr. Mears, rebuttal?
5 minutes ago, I was about ready to come up here and say I didn't have anything left to say, but that I do have a few things. First of all, we have never tried to argue about the procedures for a disciplinary report at Counsel. That is that part of that is, and I've litigated procedural due process cases in the prison for a long time, and I know that if you did it, it doesn't matter what the procedures are. David Taft possessed the nail clipper. David Taft sent the note to his therapist that was bad. He put the beans in the microwave. The question of the accuracy of the major report isn't an issue. This is not a Swanson case. We're not questioning the due process, if any, right that goes with producing the
This argument's a little different than that. He says there's an exercise in professional judgment in determining whether the microwave incident, for example, was escalated to being a major discipline report.
Well, then look at the reports that David Taft had. And it's not just the microwave. It's the microwave. It's looking out the window at the fancy car. It's looking at, it's sending a note to your therapist because you're really frustrated by being in Counsel for so long.
Yes, but let me just take it a little further. What I understand the state is saying is that the time for exploration of professional judgment and whether this is really a major offense or whether it's a fleeting problem is at the time of the major offense. I mean, the suggestion of the state is, to the extent there's any process, it comes at the time of the major report, not when the collateral damage is done on the transitional release.
Well, but the point is that these are not, we see what Counsel regards as a major report. And these are not incidents that really, in the term, in our expert opinion that we presented before, these are not really related to the ultimate question, which is he going to reoffend on the outside? That.
But are you allowed to second guess the professional, as Justice Apple was saying, the professional judgment of Cusco, that of their professionals there, that is a major violation in regards to the treatment program?
We are allowed to second guess what the legislature put in the statute.
Are you allowed, don't you have to do that at the time of the infraction rather than the collateral problem with it?
Are you suggesting that you would contest whether every single report is serious enough to be considered?
That's exactly, I mean, yeah, I mean.
There's no indication that, you could never certainly even do that in the prison context. That is, and there is no mechanism for that, that these are what Counsel regards as major reports. They are not serious, they do not relate to it, and they disqualify you from an important procedure and process that has been set up by the legislature.
Can you tell me what kind of right you have to be in transitional program, and what right are we protecting?
That,
Rises to a constitutional right or liberty, that to be in transitional.
I believe that the United States Supreme Court cases say that you have a liberty interest in avoiding being locked up. And that goes from entrance to exit. And that all along the way, you have a right, and the rights that are involved are, there's certain criteria, you can't be dangerous and so forth. You also have a right all during that process to avoid any state-created processes that create barriers to your release.
I mean, the analogy you made before was, you can't complain that you should be in work release when you're in prison because it's part of the rehabilitation program. This is part of the treatment program where you go from one to the other, to the other, to the other. And I still don't, I'm having trouble finding this constitutional right here that you're trying to apply this due process argument to.
Two very big differences. First of all, that the amalgam of the right to liberty from being civilly committed doesn't exist in prison. That is, you can't, after you've been in prison for 3 years, petition to get out because you're no longer dangerous. That is, there's something special about the liberty interest, and it's very different from the liberty interest that you have in prison.
But I have been unable to find any case that says once you're committable, for whatever reason you're committable, whether it be in Cusco or even a civil commitment, you don't have the right to have the least restrictive commitment.
Well, but that's a separate question than whether or not due process follows you all the way through the process of being able to show that you no longer are required to be in. That is, that the United States Supreme Court said there's a liberty interest in avoiding being locked up, and there's a liberty interest in getting out once no longer you have to be there.
I've seen cases that have procedural due process rights, you can't get drugs without notice and things like that, but the substantive due process right that you're claiming seems...
Well, but the substantive right talks about avoiding barriers, arbitrary barriers to being able to make your argument that you can get out. And that here you have two very substantial arbitrary barriers in those two particular provisions.
Again, you don't have to be in transitional to get out completely.
No, but it's the legislature that created the right to a hearing and the right, in connection with this transitional release program. That if they had not done that back in, and it wasn't done with the original statute, it was done in like 2002, that they had somebody who was going to be getting out and they decided they wanted some criteria, and that they created it at that point, and the legislature created this elaborate process for having an annual proceeding that looked at that. But then they placed some arbitrary barriers in the way of people being able to get there. And that, again, I think that transitional release, particularly once it gets to the point where you have a job in the community, is very much like and not that distinguishable from the person who is released with supervision, to the halfway house in Cedar Rapids. I do appreciate everybody's time. This is not very easy, that trying to identify exactly what the constitutional right is and how that works, sort of particularly in the context of a statute that in hindsight maybe we would have all preferred to have been different, but it's there. And our assertion is it creates arbitrary barriers, and those provisions should be struck.
Thank you, Mr. Mears. The case is submitted, as is in re the interest of MRW, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.